Hi, I'm Dr. Barbara Sunderland Manousso, and I'm going to be your mediator today. And I commend you both on coming to mediation, bringing this contractual dispute, because mediation is the way that you have control over the outcome of the decision. As mediator, I don't make your decision. You make your decision. But my role as mediator is that I am a neutral person, and I'm going to assist you both equally to give you that opportunity and skill set to help you see what the issues are clearly, to both be in the same reality, and to help you make your decision in a program that we call the Memorandum of Understanding, which is actually a legal contract. This process today involves 5 steps. First of all, I want you to know that I've been a mediator for over 21 years, and I also have a PhD in conflict analysis and resolution. So I'm quite capable and comfortable being the mediator for your dispute today. Now, the 5 steps involve, first of all, each of you will have an opportunity to tell me what brought you here today and what you hope to get out of this mediation session. Most mediations are about 3 hours, sometimes faster, but a normal natural mediation arc is about 3 hours. So that's what we're going to start with today. But you'll have an opportunity to speak without interruption for as long as you need to, and then you'll have an opportunity to speak for as long as you'd like without any interruption. So can we agree today that neither one of you will interrupt the other while you're speaking?
Yes.
Well, that's wonderful, because you'll see how beneficial it is to the process. One of the reasons people come to mediation is because they need to be heard, and they haven't been heard. That's why you haven't had a resolution, and that's why you're here today. But that's okay, and that's not negative. That's an opportunity, and we're going to use it as an opportunity. So first, you'll each have an opportunity to speak, as I mentioned before. Then you'll have an opportunity to talk to each other. And during this time, I want you to ask each other questions, probably things that you didn't feel comfortable saying to each other before. It's not to be insulting, it's not to upset each other, but you are here to get clarity and to get in the same reality. So that's what I'm looking forward to with you today. And I will assist you as we go down the road, not by asking you questions on content. I wasn't in your dispute, so I can't offer suggestions. I'm not asking or trying to give you a Band-Aid for this dispute. I want you to have a dialogue. This is a conversation. And we're going to keep you together in the same room. One of the things that we have found over the years, and there's a lot of evidence-based research that's been done, that when people are in separate rooms and the mediator runs between the rooms, that's called negotiated settlement. That's not even called mediation. We don't want to do that. What's most valuable in a mediation is the parties stay together and they have an opportunity to talk to each other and listen to each other. That doesn't mean that we're going to be in the same room all the time. We might have opportunities to have a caucus. And a caucus means that I'll have a private conversation with each one of you. Either I will ask for the caucus, or you can say you'd like to meet with me separately, and we'll have a caucus. And we'll go someplace private where the other can't hear, and we can talk about things that maybe you don't feel comfortable at that moment expressing. And I can help you find a way of saying it with maybe a little bit more clarity, maybe with a little bit more diplomacy, things that won't push each other's hot buttons, but will help keep your dialogue open and comfortable. When we finish this phase, we will then have an opportunity to have you both negotiate. And I'll use a board. We're going to write down the different items that you have identified. They're not in stone. They might not be the answers now, but as you start generating ideas, we're going to take those ideas and we're going to develop them further as we go into a negotiation phase. So that's what we're negotiating on. And then we will get more clarity. We'll keep diluting them. It's like when you make a sauce and you keep boiling it down until you get the salient parts of it. That's what we'll do with the mediation. And step number 5 will be that we will have a memorandum of understanding. And that is an actual contract. You both sign it, you both go home with a copy, and I get a copy that's been signed by you. And you'll take that phase, and you can file it with the court if you like, but you don't have to, or with the county clerk, but you don't have to. But it's still a contract that you've both signed and agreed to. And then if one of you breaches it, then you have a contract dispute that you could take to a court. Now, as we begin this mediation process, I'm also going to ask you to sign an agreement to mediate and a confidentiality agreement. And this is important because you are here voluntarily, that you're willing to participate in good faith. And it has to be the best of faith. You're not holding anything back, you're not going to conceal anything, you're here in good faith. So you're going to sign the agreement to mediate, and then the second document is a confidentiality agreement. Both of these documents are required by state statute. So the confidentiality agreement means just that. What is said here stays here. And I could use the cliche, what happens in Vegas stays in Vegas. Same thing in mediation. And you never tell anybody how you came to the decision you made. You might want to share with people what the memorandum of understanding stated, but you don't want to tell them how you got to those numbers. And again, other people aren't here. So they're just going to be your couch quarterbacks that said, well, you could have, you should have. They don't know, they weren't here. Don't share that information. And by law, you can't. Anything that happens here stays here. Now, we also have a convenience that we use, and it's called ground rules. And ground rules are things that will make this conversation more comfortable for both of you. So one of them that I always insist on is that you shut off your cell phones. Cell phones, if they ring, you're going to be distracted and it's not fair to whoever's speaking. So I'm going to ask you at this time, as we begin and we sign our agreement to mediate and our confidentiality, that you shut off your cell phones completely. You'll have opportunities if you need to take a break. You can ask me and I will be very happy to let you take a break, and you can return phone calls, check your phones, that's fine. But for now, no. And also, if you have any names or situations that will be a hot button or create a lot of anger in each other, maybe that's something that you don't want to bring up at this time. We're here not to get into what's happened in the past, but to bring you forward to the future. And it's a strict business deal at this point. Keep the personal stuff out. Let's move forward in a very business and methodical way. Do you have any questions on what the process is or what you can expect as we go through this mediation session? Again, I commend you both on being here today. Mediation is the way to go. It's cost-effective, time-efficient. You can mediate within a couple of hours after having a dispute. If you tried to bring this to court and to sue somebody, it would cost you thousands of dollars, sometimes more value than the dispute is worth, and it might be a year later. Your chickens are dead by then, and there are no chickens in this dispute, but that's just as an example. So again, we thank you for being here and enjoy the mediation process.
Thank you.
Thanks.